Firearms in Nevada can be confiscated for several reasons: a domestic violence arrest or conviction, a temporary protection order, a mental health commitment, or possession of a prohibited weapon or a firearm used in a crime. Today on The Right Slant, we're breaking down exactly how guns get confiscated in Nevada, what the law requires, and most importantly, how to get your firearm back legally. We'll also look at 2 real Nevada court cases to show what actually happens when citizens fight for their rights. In Nevada, firearm confiscation typically happens under one of 4 conditions: domestic violence arrests or convictions. Under NRS 200-2.360 and federal law, certain DV convictions make a person prohibited. Police may seize firearms at the time of arrest or under a court order. Temporary or extended protection orders, NRS 33.031, allows judges to order the surrender of firearms. Sheriffs can confiscate them during service of the order. Mental health holds: if someone is placed on an emergency 72-hour mental health hold, law enforcement may confiscate firearms for safety, and a judge may later prohibit possession. Firearms used in a crime or suspected of being evidence. Under NRS 179.085, police can seize a weapon as evidence in an investigation. In each of these situations, Nevada law lays out a process to reclaim that firearm, if you qualify. Nevada law is clear on what must happen for a firearm to be released. The key statute is NRS 179.085, which requires the government to return property not tied to a crime unless possession is illegal. Here is the exact process. If the firearm was evidence, the criminal case must be resolved. If it was surrendered due to a protection order, the order must expire or be vacated. For mental health confiscations, the individual must no longer be prohibited under NRS 433A or federal law. Nevada police departments require a written request government-issued ID proof the case or order has been lifted. Most agencies run a background check before returning any firearm. If you fail because of a DV conviction, an active protective order, a drug prohibition, mental health adjudication, the firearm cannot be returned. A judge will hold a hearing and the government must show why they believe returning the firearm would violate state or federal prohibitions. Nevada courts repeatedly affirm that the burden is on the government, not the citizen. In this case, firearms were seized during a domestic violence arrest. The defendant later attempted to have them returned, arguing he was not prohibited because the DV charge was reduced. The federal court ruled that because he was still subject to a court-ordered prohibition at the time of seizure, the police acted lawfully. Outcome: firearms were not returned until the order fully expired and a background check cleared him. In this case, a firearm seized as evidence was not returned even after the case was dismissed. The Nevada Supreme Court held that under NRS 179.085, property must be returned unless possession would be illegal. Outcome: the court ordered law enforcement to release the weapon to the owner, reaffirming that Nevada agencies cannot withhold firearms without a lawful basis. If you're finding this breakdown helpful, make sure you like, subscribe, and hit the notification bell so The Right Slant can keep delivering fact-based, no-nonsense firearm law content. A few important Nevada-specific details. Nevada does not have a red flag law. Firearm removals must occur under existing DV or mental health statutes. Counties may have different forms or procedures, but all must follow NRS 179.085. If your firearm is destroyed or lost, rare but documented, you may seek compensation, but only after proving lawful ownership and unlawful retention. Nevada has a straightforward but strict process for getting a confiscated firearm back. If the case is resolved, if you're not prohibited, and if you follow NRS 179.085, the law is on your side. Thanks for watching The Right Slant. Stay informed, stay prepared, and know your rights.